Hello and welcome to another lecture of the law of the sea. Today we're going to talk about the sources of the law of the sea. So this one's a very important lecture and I hope you will learn some things from it. I am Muhammad Tahmidul Islam, lecturer, Department of Law, World University of Bangladesh. So let's begin. Introduction. International law of the sea is a vast area of law belonging to the broader spectrum of international law. It is a part of public international law. Therefore, the sources of the law of the sea are similar to the sources of international law itself. However, as a special body of law, the international law of the sea has unique sources which have been described below. United Nations Convention on the Law of the Sea. The primary treaty on the law of the sea is the United Nations Convention of the Law of the Sea, 1982, or it is called, in short, UN Clause. It was adopted in 1982 and it lays down a comprehensive regime of law and order in the world's oceans and seas, establishing rules governing all uses of the oceans and their resources. The convention embodies in one instrument traditional rules for the uses of the oceans and at the same time introduces new legal concepts and regimes and addresses new concerns. It also provides the framework for further development of specific areas of the law of the sea. It entered into force in 16 November 1994. It has 157 signatory parties. Bangladesh signed the treaty in 10 December 1982 and ratified it in 27 July 2001. It is also called as the Law of the Sea Convention or the Law of the Sea Treaty. Now let's talk about the customs of the sea. Customs of the sea are norms and unwritten rules that have been observed by ship's captain and crewmen for centuries. In the open sea, ships had to sail for months at a time. Therefore, they developed their own rules of engagement and procedure to maintain order and cohesion. One infamous custom is cannibalism, which allows the passengers to kill and eat one of them to survive in case of dire emergency. For example, lost at the sea. If they are lost for a long time and they have no other means available, they can eat other dead members. So that is the extreme scenario, and that is also a part of the customs of the sea. Principles of the law of the sea. International law of the sea is based upon certain principles that help develop this branch of law. One of these is the freedom of the seas. This is the doctrine which advocates that sea areas are mankind's common land and no state can exercise jurisdiction over it. Another prominent principle is the environmental conservation of international sea doctrine. This doctrine says that it dominates policies now regarding international waters. So environmental conservation is being talked about more and more these days because environmental conservation is really important, first of all, and secondly, we are doing our economic activities in such a destructive way that we need to take care of our environment. Otherwise, our future generation will be at risk of facing a lot of adverse environmental situations like typhoons, tsunamis, and etc., and a lot of other scenarios where they will be faced with dangers, a lot of dangers, which may disrupt their lives in such a way that we cannot even imagine. Admiralty law. Admiralty law or maritime law is a body of law that governs nautical issues and private maritime disputes. So admiralty law is actually the private international law part of the international law of the sea. Admiralty law consists of both domestic law on maritime activities and private international law governing the relationships between private parties operating or using ocean-going ships. While each legal jurisdiction usually has its own legislation governing maritime matters, the international nature of the topic and the need for uniformity has, since 1900, led to considerable international maritime law developments, including numerous multilateral treaties. Let's talk about international treaties now. International treaties are binding agreements between nations that agree to abide by certain rules in relation to each other. The United Nations Convention on the Law of the Sea is the main treaty in relation to the international law of the sea. The London Convention on the Prevention of Marine Pollution by Dumping of Wastes and Other Matters and the Montreux Convention regarding the regime of the straits are also examples of international treaties that make up the law of the sea. International organizations. The International Seabed Authority, or in short form ISA. It is mandated under UN Convention on the Law of the Sea. Its main goal is to organize, regulate, and control all mineral-related activities in the international seabed area for the benefit of mankind as a whole. ISA has the duty to ensure the effective protection of the marine environment from harmful effects that may arise from deep seabed related activities. The Commission on the Limits of the Continental Shelf. Its goal is to facilitate the implementation of the United Nations Convention on the Law of the Sea, or the Convention in short, in respect of the establishment of the outer limits of the continental shelf beyond 200 nautical miles from the baseline. It also provides scientific and technical advice if requested by the coastal state concerned during preparation of such data. International Adjudicative Authorities. The International Tribunal for the Law of the Sea. The tribunal is an independent judicial body established as a specialized tribunal to deal with disputes arising out of the interpretation and application of the UN Convention on the Law of the Sea. The tribunal came into existence following the entry into force of the convention on 16 November 1994. The tribunal has jurisdiction over any dispute concerning the interpretation or application of the convention and over all matters specifically provided for in any other agreement which confers jurisdiction on the tribunal. Statute Article 21. The tribunal is open to state parties to the convention, also known as the states and international organizations which are parties to that convention. It is also open to entities other than state parties, or states or intergovernmental organizations which are not parties to the convention, and to state enterprise and private entities. So it is actually, the tribunal is actually open for almost all parties who are part of it and who are not part of it as well. So this is the end of the lecture, and here we can see that there are certain important terms and important institutions, important cultures, important treaties and admiralty law, some principles, customs. So these are actually important parts of the international law of the sea. I hope you have understood the lecture content, and if you face any problem regarding understanding the lecture contents, you can always ask your questions or comments in the comments below. I hope to see you all in the next lecture. Thank you all.